assume for the sake of argument that we don't accept your position that misleading and false are synonymous, that there are some things, borrowing the phrase of your the other side, some things that are true but misleading. Just as 100, if you say a packet of toxic mushrooms is 100% natural, toxic mushrooms are 100% toxic, but it may be misleading if you're selling it because people may believe that it's safe, that you can actually eat it. So that's misleading but not false. So assume that there's a difference between the two. And we say this is a Bronston case. It has to be a false statement in the sense of Bronston. How is this, what is the difference, or is there, in what you're saying about what falsity means in this statute and what we said it meant in Bronston?
Yeah, yes.
The other side argues, and there's many who have described Bronston as saying you need literal falsity or literal truth. So how do you distinguish what you're arguing, or how do you get what you're arguing from what we said in Bronston? If we answer the question presented, that you can only prosecute false statements, all right? Staying within Bronston, how do you argue this case?
So we disagree that the rule this court announced for the perjury statute in Bronston applies to the language of 1014.
Assume we disagree. Because there it was, the perjury was for making a false statement. Here, if you make a false statement, you're guilty with some other knowingly, et cetera, other elements. So just go back to the essence of my question. If we apply Bronston, do you win?
So I do.
Or how do you win, and how does your theory fit into Bronston?
I do just want to be very clear that I do not think this court should apply the perjury statute.
I understand that.
Sure.
I've said it 3 times. Assume.
Okay, and then I would point this court to the footnote in Bronston where the court said, of course, understating a numerical amount in response to a question would clarify or would qualify as literally false even under the rule that we're announcing today. And we don't think you need to have, of course, Bronston was talking about questions and answers during testimony, but we think that here, for instance, the invoice essentially served the same contextual purpose as a direct question about how much petitioner owed. But it's the principle is the same. The court was saying, of course, if you only state part of the whole.
Now we go to Justice Gorsuch's question. When we describe context, the other side says, "What's the question asked, directly or implicitly?" You're not, but I think he's not going to say implicitly. What's the question you ask? What is the answer you give? And objectively, do the facts support that answer? How would you describe what we're supposed to do?
I think petitioner's limits to just the precise question asked is very artificial. I would draw an analogy to how this court looks at context with statutes, for instance. This court does not draw hard and fast rules saying we only look at the preceding subsection.
But that's what we did in Bronston. We looked at the question asked.
In the context of cross-examination where the questioner is in full control of the witness's presentation by asking the questions and against a background principle of Anglo-American law that we want perjury to be.
If we disagree with you, is that the lesson you take from Bronston? That it's the question asked and whether the answer is objectively right or not?
In the context of perjury, yes, I understand that to be the case, though, of course, I think you have to look at the question. But you're arguing we should apply
something different in other contexts?
Than perjury, yes,
right.
I would.
Thank you.
Counsel, we've been talking about things that are technically true but misleading. Does it work the other way? Let's say you have statements that are technically false but not misleading. If someone's trying to sell you a horse and says, this is the fastest horse I've ever seen, and in fact it's not. He's seen a faster horse. But I don't think purchasers would necessarily view that as misleading. they would view that as sort of normal sales talk. So can things be technically true, technically false, but not misleading?
I don't think in your hypothetical, Your Honor, that would be considered false because it's in a context where, I mean, it's a qualitative opinion, for instance, and so the listener
No,
takes that with a grain of
either
salt.
one horse, they had a race and the horse
Oh,
won.
I'm sorry. Yeah, so I think in the context of what is essentially sort of puffery, the common law, like the reasonable listener sees that differently, and there are common law doctrines that kind of give effect to that. And so, no, I don't think that would be false in your hypothetical.